Hello, YouTubers. Good evening and good day. It's been a little bit since I've been on here, but I've been working on things. I'm always working in a good way, both physically and on paper. Paper is highly important, like I've said before. I've compiled a letter of rogatory here. And this letter of rogatory is going to go to a probate referee. Now, keep in mind, this is all for entertainment purposes only. We want to entertain the right parties and have them laugh with us instead of at us. We like laughter in a group setting with us, not to be laughed at as the joker. No, this is no joke, but it is entertainment. And we entertain good thoughts and good things. And we take our energy and entertain it in the proper way. So we like to entertain and keep a smile on our face. Smiles are good things. I'm going to read a letter of rogatory here. And what it is it's a private document to a foreign jurisdiction. Now, if you have title over your trust or your estate or over your corporation and a business owner with a trade name, you now can be controlling interest. You don't own it, but you control that which you don't own, which is in your jurisdiction to do so in your private capacity. This is what we do, and this is entertainment, and it makes me laugh. But it's the best entertainment you can have because it sets you free and makes you laugh. Isn't that the purpose of life? To be happy? You know, you've heard the old song. Some of you. It's way past your time or before your time. Don't worry, be happy. You can look it up on the internet. You can look it up on YouTube or whatever venue app you're on. Don't worry, be happy. Be entertained. I'm going to explain some of this. Through this letter of rogatory, I'm also turning it into an affidavit of truth. And for me, I've mentioned apostilles, and I've mentioned authentications through the Secretary of State of the United States. And so therefore, we are controlling that interest with titles. And you can go back to some of my previous recordings on this statement, and I explained some of this. Now, when you do things in private, you don't want to mix them with public. You want to keep them private. So for letter rogatory, let's say you're serving it on a probate referee. You're going to keep it in the private form, which means, and I like to double things up, but for the most part, do it with a personal service. Now, a lot of you, some of you, have been divorced, unfortunately. Sorry to hear that if you have. But you can, as I've been through it myself, it's never fun. It's like a death. But there is hope after that. So if you're going through the middle of it, you have my prayers. You'll get through it. It will pass. You do personal service. So you have a witness now and personal service to serve this affidavit of truth, which you have notarized, and it stood for 21 days. You got it apostilled. For me, I did mine under my full faith and credit headings, which I have all categorized on a list. And this under my annex full faith and credit document over my birth certificate security. So it falls under that as title and controllership. You don't want to own it, you want to control it. You're not it, but you're controlling it. What is it? Well, it's the all caps capathonym, which is an image. And I've said this before. So I did my personal service, and you put a number on it. Now, you could have the sheriff do it for you, or you could have someone close in proximity who knows where this person acting as an agent is, aka could be a probate referee, could be anybody who's operating as a dead decedent or an agent. I put my full faith and credit document number on it for a personal service number. And then what you'll do is you'll have someone deliver that to them. You'll pay them a fee or a service fee for it. And then you'll have confirmation down in writing in reference to that personal service number as it is finished. They did it and they're a witness to it and it's been served. And that's a lawful document. And it's lawfully been served in the private capacity. Now, in addition to that, you can put a registered mail parcel on it. And I have registered mail stickers for under the United States Post Service, which is the label 200N as in Nancy, N as in Nancy, label 200N, and it has a number on it, PSN dash, quite a few numbers behind it, and you can put that on the upper right hand corner side of it and affix it to your document. And it's the labels that you have in your possession that makes it private. Registered as private, certified mail is public. You want to keep it in private. So have everything referenced to private and under the authority, under the jurisdiction with a registered mail number, which is now under the authority of the Universal Postal Union, which is a higher authority than who you're serving it to as well. And if there was ever an issue, you could report it to the postal inspector in Bern, Switzerland over the Universal Postal Union because they're the highest authority in mailings. And people are accountable to that for mail fraud. But personal service verifies that it was done under that capacity as well. So now you have a double layer. It's good to reinforce yourself and back yourself up. So here we go. I'm going to read this document. This is an affidavit of truth, and I could easily get this in all affidavits. You get them notarized into the public, or you can do two witnesses, or you can do both. But if you notarize it into the public, then it covers the communications between private and public, and it's a certified document. But you can go further, like I'm doing with this, and you're going to put it under the apostille certification, which is from the state authority, and you do it under the numbers of your authenticated certificate, which you have from the Secretary of State of the United States, under that apostille number. And all those numbers coincide behind that, under that number, and it forms an authoritativeship of annexed document, securities, and everything below that controls that. But you're controlling the top level of that point. That's the idea here, and that's the procedure. Now let's get into the letter of rogatory. And I put on this letter of rogatory, notice for private use only, not for public case filing. You don't want it filed into your case. This is a direct communication in private venue to the probate referee or whoever is a controlling interest over something that you have personal private interest in, that's your property. Notice, for private use only, not for public case filing. Any case, a court case, any case. This is direct communication between you and the other agent. Void where prohibited by law. You're always covering yourself under the law that anything in this document, if it were to be faulty or an error, and they wanted to file suit on you because of something you've written down, there isn't any in this document because I know what the rules are and I've studied it and I went over it and I researched it. I know what I'm doing in this area for this document. I made sure. But you cover yourself and you put void where prohibited by law. Now you take the liability off of yourself in this document. Now, under title and authority, first I put the date of the document that was drawn up. And then under my decedent's name or my trust or business name, I'm doing business as, because I have a certification and recorded with a county and apostilled under the full faith and credit annex document, apostilled through the state as doing business as. And I do care of the address that the decedent is coming from, which is also my private address. But care of, if you do care of under your full address, it should cover the zip code too. But you can put near your zip code, or you could put your zip code in caps or quote marks, which covers the four corners rule. Okay, which means it's not a part of that jurisdiction of the United States zip code jurisdiction they overlaid onto this country as their property, when in fact you're only using that system in controlling interest. You're not of that system. Basically, it's the adage of we're in this world, but not of this world. Or we're of the United States, but not in the United States. We're near it, but not in it. You could reverse it that way as well. I put down full faith and credit under that with the number for under the United States of America authenticated birth certificate. Now under United States Code, I put in quotations. It's or colons. It's a testamentary instrument. Under United States Code, it is a testamentary instrument, and it's valid. On number two authority, apostille with the number, with the state that I'm in, certified, authenticated, annexed security instrument, birth certificate, under the public charitable trust. Well, the public charitable trust is the major trust account that controls your minor account, which falls under the SSN number. And under that authority, I have listed DBA. It's an apostille with a number for that DBA that I recorded under the annex certificate. And it's my county's record, and I have that recorded in the county. And mine was in the year 2018, following the number of that document. And then in quotations, I put certified and recorded. I'm making it clear. I'm writing it down. This way, this agent knows, the probate referee knows that I have my stuff in order and I'm controlling it and I have title in it, and they don't. You're the controlling interest. You're steering the ship. You're the captain. You're the king of your estate. You're the captain of the vessel. And you have trust in the air cover. Law, LAW. Nothing to adjudicate. You own it. But you own title and controllership. You are not it. So there's no assumption and presumption of you being the trust and the surety and collateral for the debt. This is the idea, and this is why you do this. Now let's read. Back down here a little bit. Relax. Communication I'm conveying is from my personal studies and experience from the last 7 years. I'm writing this letter in my private capacity only. This letter has not been copied or pasted, but comes directly from my knowledge and diction through focusing on the law in public and private venues. I will continue to study and endeavor to remain in honor in lawful and legal affairs in both jurisdictions and commerce and under the Uniform Commercial Code. I am requesting this communication to be private and not filed in these courts or any public venue without my permission. This is exclusively a foreign sovereign administrative private communication and negotiable instrument for settlement and closure. As United States Code Title 18, I'm identified as an American state national and not a U.S. citizen debtor in status. I am the business owner and principal of the Clinton Squire estate. I wish to settle and close the charges against the estate. I realize everything in this life requires direction and responsibility, even during the times of angst and self-imposed missteps in our journey of daily life. I wish to act responsibly and discharge the debt that has been assigned and litigated against the surety, the all caps name. This would include any variations of capathonym that were formed and charged during these cases, assessed under the table of your state code as criminal penalties against the trust. As principal, I would like to set off the debt incurred and tax imposed for cases and remain competent and in honor. This letter is purposed to settle and close the matter and not adjudicate in the cases whatsoever. Thank you for your time and attention. Now, under that, I'm labeling notice for private use only, not for public filing. Void were prohibited by law. And I put these in bold case letters and with a bigger pattern size, just so it's not overlooked and it's clear on the paper. So this is definitely private, and I'm making sure it's staying private. And there's no doubt or issue that it's to be filed on anything other than communication with the agent who's responsible and in control of being able to settle and close things and adjudicate things, aka a probate referee. Here's my authority. Under the State Code 559.8 Common Law Declaration Power of Appointment Act of 1951, under the United States Code Titles 26, 2038, 2042, 1514, and then under the State Code of 55914, 559.7, and under the State Code of 602, 8108, 633.40, subsection 4. Now, I'm including this as the authority on here, and I'm mixing the United States Code with the state code because you don't want them to say, "Well, that's not our jurisdiction." No, it is the jurisdiction under the United States Code, and it's all legislated in the state codes. They just change the numbers and move it around a little bit. The 50 several states are a part of the United States, and they do have a federal district in the capital city of your state. It's in the same jurisdiction, and that's in the United States Code too. I just don't have it currently on in my brain here on what that is. I'd have to look it up. But it is a part of the United States, and it's the same jurisdiction. Make no mistake about it, and don't let any attorney Barfly ever lie to you about that. Let's continue to read. Now, the most important about this document is you're the beneficiary of the trust. You're the controlling interest of the trust. Most importantly, this trust doesn't exist unless you're the donor. Well, your informant, your mother made you the donor by informing them that she's donating you to be registered as a public charitable trust. And through probate referee, they put you to death. Okay, that was a little rabbit trail. For entertainment purposes only. I hope you're entertained, because I sure am. By it. Let's continue. I'm the beneficiary. Here, let me have a drink. I'm the beneficiary and donor of the trust of the all caps name estate. Therefore, I would like to appoint the clerk of the court as trustee. I am revoking the executor position as acting in a constructive V trust agent capacity. Now remember, V under the SESTK V trust, V means competition. It means it's being competed for. You're competing against someone, and you're competing against a district attorney for a position that you are the executor and they aren't. But if you don't raise it, you waive it. That's where the V is. I am revoking the executor position as acting in a constructive V trust agent capacity. And it's a constructive trust. That's what makes it a V action. They're competing. And so they're constructing you under performance. And we'll go into performance in a minute because those are all covered under bonds. That position comes from the district attorney agent of the state of your whatever state you're in corporation. In addition, as a revocation of power of attorney filed an apostille number certified for the beneficiary. These attorney agents are in acting capacity only and are considered incompetent to represent any decedent acting as a principal for a corporation as in that position only. They're an agent. They're not a real party of interest. The only one who can represent a corporation is the CEO or CFO or the agent, the real principal live party of interest who started the corporation doing business as. Then formed it either into a C corporation, an S corporation, or an LLC corporation, limited liability. Make no mistake about that. Or a charitable corporation under a 501c3. Unincorporated. Foreign unincorporated. Corporated unincorporated. They have all kinds of maneuvers. We can use them too. In addition, as a revocation of power of attorney filed in under the apostle document that I have listed under my full faith and credit, certified for the beneficiary. This identifies me in title. These attorney agents are in acting capacity only and are considered incompetent to represent any decedent acting as a principal for a corporation as in that position only. This has been proven through the Dead Man Statutes, Rule 601, United States Code, Title 26, Sections 303, here in the Superior Court of my state in the year 1966. Well, that case was defeated by the attorneys who had complaints against the defendant in their principal capacity because he was the only real party of interest and the rest of them were incompetent. An agent can't represent a decedent of a state of, or a corporation agent of. You're an agent. You're an officer of it. I'll continue. I would ask that you officiate as a witness and judge to the fact of this matter and order and or appropriate the right focus and energy for the principal's best interest in commerce. I'm requesting an outcome for the favor of all parties involved as appointed trustee. I ask the clerk of the court to credit and discharge these cases and remove them from the record. See, now I'm acting as the king of my vessel, I'm directing it, and now I'm making orders. Because I'm the boss and I'm controlling it. I'm controlling interest by title, by record, by certifications, your holder and holder in due course. No one else has your documents. No one else has that authority over you, not even a probate referee. You tell the probate referee what they're going to do in this case. I'm not saying you walk in there and you be belligerent. You do this with respect and authority and under these laws and codes, because those are for them, not you, the principal. Why? Because you don't come in as an agent. Those are for the agents. I put down, I quote, and this is my negotiable instrument that I'm setting off the debt with because I'm the creditor. I accept these charges for value and consideration from the cases, and I listed the two cases that I had, for charges in the amount of, and I left the amount out because I don't have the certified amount yet. That'll be up to the clerk of court to determine. Please accept the auto trust and QSIP numbers under the United States Patent and Trademark Office under Standard & Poor's, a corporation, in the bottom floor of the Depository Trust Clearinghouse Corporation with the numbers, which is your social SSN number without the dashes. That's the auto trust QSIP numbers they created. They have them trademarked under a patent for post-settlement enclosure in these cases and expunged from the record. You want them taken off the record, and you want them off your decedent's credit score under FICA, because it affects your performance later on down the road when you're trying to obtain things by credit or a credit card. Yeah, it's a defamation of character. Authority number 3, United States Code, Title 15, unfair debt collection practices. Why? Because they're a private corporation doing business as, and they're acting as debt collectors. You go into Title 15, they're debt collectors. They're not a government because they have a QSIP number. They're on Dun and Bradstreet, and they're foreign for-profit private corporations acting as government. And they are in fact not. So Title 15 under United States Code unfair debt collection practices comes into play. In addition, United States Code Title 31, Sections 29-24, by probate, because the probate office is always open in these courts. They're probating your estate. That's how they're collecting your good under the power of sale, which 725, 726A, and under my state's code C11.1, liability immunity from civil criminal prosecution and administrative proceedings. That's for the principal under United States Code Title 31, Sections 3128, and that falls under the presumption of death. Well, when you show up as a captain under common law and you have all your effects in order with the titles and controlling interest, and by special appearance, now the presumption of death is now assumed and consumed, isn't it? I'm being entertained, and that makes me laugh. Excuse me. Have me another drink of liquid. I will continue. That was under that authority. Now I will continue on with these authorities, making my statements and direction, not owning it, but controlling ownership of the interest, which is your trust, in all caps. In return for damages incurred with arrest, excuse me, court charges, and the FICO score, bad credit score, reporting against the surety of the all caps name estate, I, the principal, am requesting damages and compensation for the monetary amount to be credited to the donee's estate. I'm a donee of the birth certificate. Donee controls it all. Remember that. In addition, with tax recovered under qualified terminal interest property, this is under the legal codes. This should be determined by my state's code for recoupment and compensation for the principal's benefit, the real party of interest. This would include recovery from the expenses that are assessed from the performance process of administration of will, deed, competency. They like to make you incompetent, but you're competent now because you're the principal. You're the donor. Of course you're competent. They like to call your decedent incompetent because he's not settling and closing the account they're charging. And you're competent, you take care of your financial affairs through negotiable instruments. We'll continue. Pain and suffering with defamation of character. Yeah, they're defaming your business character. And they're putting bad credit scores on you when it happens. Charging it, saying you're not paying. This has transpired from complaints through codes and accusations to the heirs estate by tacit and assumptions or identity for the all caps character they created that I'm in controlling interest of. Now, tacit agreement means it's assumptions and presumptions, and if you don't say anything, it's assumed, and then therefore they take controlling interest over your property. And it's assumed that you know what's going on, and you're a professional now in commerce, and they're dealing with you. But if you're not performing, you're incompetent. I'll continue. These matters have been charged against the Public Charitable Trust, which is a registered birth bond with the number they put on that, and the trust minor account, which is your SSN number that you have on your card. And then that it also converts into auto trust QSIP number, and then and or private Federal Reserve bond number. Mine's from Atlanta, Georgia. I'm talking about the number on the back side of the card, which has a number to it in red letters, sometimes black letters. All these accounts, including the court cases. Now, I'm going to back up here. When you see red letters, that's private. Anything in black is for your decedent. Blue is under control of the security bond, which is your birth certificate bond or bonds. Gold, you come in as a king and your executorship. You can use all three colors of these pens to designate what you're conveying on paper and how you're coming in, and even positions of signatures on the paper signed. Left side, middle, right side. Well, this I do know for sure. Middle, down the middle, is you're signing for your trust. You are the trust. These are little details, but they can be big details. Depends on what you're filing. All these accounts, including the court cases, are certified by my apostle with the number state of the in the state as personal property of mine, as principal and certified public knowledge, and annexed under my full faith and credit, which is the number from the United States of America from the Secretary of State's office. Now we're dealing with jurisdictions. That Secretary of State of the United States is over all these corporate fiction agents over the United States, which controls the states. Authority number 4, TILA, public law, under adverse claim. TILA, public law, adverse claim, under adverse claim. This is your recoupment. You have an adverse claim, and it's under 111-111-203, sections 1413, done on July 21st, 2010. And this is a property interest into a financial asset. You being the principal, it's your property now, because you've claimed it and you've declared it and you've showed it on paper, and there's no question, and it's under the authority of full faith and credit annex securities under the public charitable trust, which controls all the minor trust accounts, a K trust under a V action, which you've taken the V out of it because now you've come in as a real party of interest. There is no V here. I'm taking that over. I'm closing the V down. No competition. I continue. The amount assessed from the recoupment is requested to be credited for the accumulated charges in their entirety for the 2 cases in this letter that I'm situating as. They are purposefully left open for the clerk of the court, who is now trustee, and her aides. Why? Because I appointed her under the Power Appointment Act. And it's releasable with all power and can't be revoked in a court setting or in any kind of paper setting that you're doing in this case, especially in the letter rogatory, which is a private capacity under common law. I do not, okay, where was I? There are okay. The amount assessed from the recoupment is requested to be credited for the accumulated charges in their entirety for the 2 cases. They are purposely left open for the clerk of the court, the trustee, and her aides to assess and determine for full settlement and closure. I do not have the access to the full certified amounts and administrative charges that have been assessed to be settled. Well, you don't have access to that. They do. The clerk does, and her associates, the barflies, her aides. I'm also requesting that the bid, performance, and payment bonds that were endorsed in my name be returned to the executor of the state. Thank you for your cooperation and acknowledgement and any suggestions in advance. Well, why am I asking that? To accommodate what needs to be done if they need any info from me, which I doubt they do. But it's just a gesture of good faith that you're not being belligerent and you're being, because they're taking a blow through this paper. That probate referee's getting her knees knocked out. He or she, from under him. You just blew the door open. I want to continue with the bid bond. When you go into that setting, they put a bid bond on you. Then they do a reinsurance bond, which is known as a performance bond. Now, your performance, as I mentioned earlier, referring to this, is how you perform in this situation. Are you coming in as the debtor or the creditor? Well, they draw up a performance bond on you for that reason. Are you incompetent or competent? That's your performance. Then, if you don't perform, there's a payment bond. That payment bond is assessed either for you or against you. So you're going to go in there and settle and close the case. And this is how you do it. And let me read it to you again. I accept these charges for value consideration from the case for the charges in the amount of whatever the case is listed as, if you know it. Please accept the auto trust and QSIP numbers your SSN number without the dashes for post-settlement enclosure in these cases and expunged from the record. Then what you do is you direct them, as I've stated in a longer paragraph, you direct them that you want compensation for damages against your estate. You're the king. You're claiming your stuff back. You're directing it. You don't own it. Excuse me. Because they have access to it too. But there's no V in the action now. You're controlling them and directing them on what to do and how to get your funds back under taxable termination and recoupment. So you're terminating the taxes by having them settle and close the case accounts, and you're getting recoupment for damages now, because when the thief is caught, they have to repay sevenfold, don't they? What says that in the Bible? So get your funds back. Take authority over it. Be the king. You can't be shaky on these issues. You have to know what you're doing. At the bottom of this document, I put best in regards and in honor. I'm in an honorable situation. I'm competent. I'm not belligerent. I'm not being combative under the War Powers Act, Trading with the Enemies Act, and Commerce under the Uniform Commercial Code. They look for that too in your performance. You go in there with your shoulders squared up, and you own that court because you're coming in as a king. And you have your trust in order. You're the king, and now you own commerce under the Uniform Commercial Code, and you're directing them through negotiable instrument how to settle and close under post settlement. You're settling and close it. You're closing the case. Okay, so you're doing this by consideration, value, and consideration. Those two words are in the legal codes for having the authority and knowledge of what you're using and what those words mean. Value. You're the value, considering you're the directing your trust, which is unlimited value. Okay? Post settlement and closure. Post settlement is for, like in this situation, they've already got all these performance bonds and payment bonds drawn up. So it's already in place before you even get there. So it's post. It means from the past, it's settled. They've already started it. That case doesn't exist without those bonds being in place. Like I said at the last statement, I'm also requesting as the king that the bid, performance, and payment bonds that were endorsed in my name be returned. Excuse me. Pardon me. To the executor of the estate. That's your property. I signed at the bottom. I put authorized representative, by authorized representative. Your signature, then authorized representative. Good as avail. Avail means good as avail. That means good as gold because they took all the gold from us in HCR 192, 1933. We are the gold. We're the surety and collateral for the trust. But how you direct and do the trust depends on who the surety is and who the collateral is. Are you the principal, or are you going to be the surety and the collateral, or the guarantor? You don't want to be the guarantor behind bars or the surety behind bars for the collateral of the debt that you were incompetent to settle and close for post settlement and closure under value and consideration. I hope for entertainment purposes only, this stuff is sitting home and hitting home and ringing some bells and making you laugh and smile for entertainment. You want to be laughed with and not laughed at. I signed it from the estate of. I put two categories because on bond documents there's two categories. You're the principal or the surety. Your principal is your lower caps name, proper diction, which is your first name hyphen, middle name, and then colon, your last name, comma, beneficiary. Then I put in quotations donor executor. There's no mistake on who's signing this document and who's the principal. And the surety, I put the all caps name, comma, the guarantor, and then I put my full faith and credit numbers from the Secretary of the United States as full faith and credit annex securities behind that. That definitely gives me authority to be able to set off these charges for debt and be competent over my estate. Ladies and gentlemen, I hope this helps you tonight and today, wherever you may be. I've shared some really important information with you. Please watch over this a few times and let it sink down into you and do your own study and research. If this is a valid letter of rogatory, in addition, it's an affidavit of truth and it won't be rebutted because I have all my authority of laws on it. To do what I'm saying, and everything I'm saying is capped from top to bottom, and I'm controlling that vessel. Be blessed. Have a good day and evening, wherever you may be, and I hope you've been entertained. Love and blessings to you. Be vigilant, stand strong, and have victory in your life. And most importantly, walk around with a smile and confidence on you know who you are, and then line all your papers up accordingly. Bye bye, folks.